Good day. I have with me legal expert, Dr. Llewellyn Kerloos of the University of Pretoria. And the conversation on the table today is former President Jacob Zuma's application for leave to appeal that was refused by Judge Piet Koen today. And we're going to talk a little bit about the technicalities of the case with Llewellyn. Good day, Llewellyn.
Thank you, Isak. Thank you for the invite as well.
Okay, so let's just recap here. Why was Zuma in court today?
Right. So what happened is, you'll be mindful of the fact that during October 2021, there was an application before court for a so-called special plea. Now, a special plea is a plea that the Criminal Procedure Act, specifically Section 106 of the Criminal Procedure Act, makes possible for any litigant, in this instance, the accused and his legal team, to raise what is known as any other plea other than one of guilty or not guilty. In this instance, the allegation was that the prosecutor lacked title to prosecute for whatever reason. Now, those arguments were advanced, but the application was subsequently dismissed. And after receiving the judgment for the dismissal of the special plea, Zuma's legal team decided to attempt in appealing that, let's call it an interlocutory application that was dismissed. Now, arguments were attended to, and today what followed was the application for leave to appeal, because you're not entitled to take a matter on appeal unless the same judge or presiding officer grants you leave to appeal to do so, based on the principle that any other reasonable court might come to a different conclusion. The judge said, no, this application of yours is frivolous, there's no merits in it, and there's no possibility that any other court might come to a different conclusion. So the application for leave to dismiss was subsequently today in court dismissed as well.
And it took Judge Piet Koen only a matter of minutes to take it off the table, and he was quite adamant that the case should go ahead now.
I have no doubt in my mind that his judgment today was spot on. I'm happy with the judgment. In actual fact, in very few, if any, criminal cases in this country in the last 100 years, did any interlocutory application succeeded on appeal. What the criminal law, unlike the civil law, expects judges and magistrates in criminal cases to do is to finalize criminal trials. We don't like the so-called piecemeal approach in criminal trials. If you, as the accused, persist that there are certain shortcomings, irregularities of some sort, etc., during the course of the trial, including this interlocutory decision that was handed down today and in October last year as well, then by all means, at that stage, after the matter has been finalized in the court of first instance, in this instance before Judge Koen, then you are at liberty to take the matter on review or on appeal to a higher tribunal, which will then be the Supreme Court of Appeal or the Constitutional Court. The fact of the matter is, that is the way the process works. You cannot allow a piecemeal approach. In other words, that a matter be finalized on one issue now, come back to court in 6 months, and then proceed for another month or two, pending another interlocutory application, because no criminal cases will ever be finalized if that is the attitude and the way the law plays out.
So, Llewellyn, what can we expect now? Will the case go ahead now on 11 April, or will there be another surprise move?
Well, I'm on two minds here, Isak. First of all, the judge said the matter will proceed at 10 a.m. In April, I think April the 10th or the 11th, roundabout. The fact of the matter is that is his order, so he will be very, very reluctant not to proceed with the matter on that day. Even if the accused person is adamant and is malicious in his participation in court, then the judge can, out of his own cognizance, we talk about mirror motto. In other words, he can do it himself. Enter a plea of not guilty, and the matter can continue. It can even continue in his absence, so to speak. But those are the exceptions to the rule. It's not, one would like Zuma to participate and be there because he wants his day in court, and now he's got his day in court. That being said, I will not be surprised, on the other hand, if Zuma's legal team attempts to file what is known as a petition in this process. In other words, directly approach the president of the Supreme Court of Appeal in Bloemfontein for so-called substituted consent to take the matter, and in that instance, this matter on appeal to them. But fortunately, that is unheard of. It's not the way the law is supposed to work. And I have no doubt in my mind that the president of the Supreme Court of Appeal, if such a petition is filed with them, will take no nonsense and subsequently dismiss that petition as well, which means that in April the 10th roundabout, the matter can proceed, no problems at all.
You are aware that the phrase "it is unheard of" in a South African context is always heard of.
Isak, that is exactly why I said I'm on two minds here. I know the law and I know how the law is supposed to work out and play out. But that's why I said I'm mindful of the fact that there might be one more avenue to pursue. And that is exactly what I anticipate will probably happen within the next couple of days. But even if they pursue with a petition, what I'm saying is come April, mid-April, by that time, even the Supreme Court of Appeal, if such a petition is lodged, can have already made up their mind and dismissed that application as well. And then there's absolutely no other way to pursue the matter.
So let's assume we start on 11 April with this case. It's not going to end next month or even next year. Am I right?
No. You are spot on with that conviction of yours as well. The fact of the matter is this is going to be a long drawn out trial. Fortunately, a High Court have a rolling roll. In other words, on a daily basis, the matter can proceed until finalization. It's not like the lower courts where you will typically see 1 or 2 days set out for the trial and then the matter gets postponed for months on end to only to proceed later on again. The matter will start and will continue until finalization. But on the best scenario, in any event, we are talking here of a number of months before the matter will be concluded, maybe even a number of years.
That is Dr. Llewellyn Kerlewis at the University of Pretoria. Thank you very much for your time, Llewellyn.
My pleasure. Have a good day. Bye.
Goodbye.